and welcome to Keynotes from Cornell University. My name is Nicholas Phillips. Today is all about navigating communications with your company's in-house counsel and some legal concepts that can help you in the future if you ever need to interact with your company's attorney. Joining us in studio is the Associate Dean for the Cornell Law School, Michelle Whelan. Michelle also happens to be the faculty author of our Legal Writing and Communication Certificate. Before coming to Cornell Law School, Michelle practiced commercial litigation for 16 years in Miami, Florida. Michelle, thank you so much for joining us in studio.
You're welcome.
I appreciate it. And before we get started, I do have to say, go Hurricanes. I am a Hurricanes fan.
Okay, that's great. Thanks for having me.
We appreciate it for all those college football fans out there. Before we kind of delve into some of the legal concepts, I kind of want to baseline our conversation for the audience a little bit. We're going to be talking about corporate litigation and lawsuits. So how should we think about civil litigation and corporate lawsuits versus maybe criminal litigation?
So when lawyers think about lawsuits, they think about two very broad categories.
Okay.
Civil lawsuits and criminal proceedings. When we're talking about criminal proceedings, usually someone is alleged to have committed a crime, and a government, whether it be state, local, federal government, is prosecuting that individual for that particular crime. And the penalty for that person being found guilty for a crime is usually some sort of custodial sentence or a fine, a penalty. And in terms of civil litigation, the government is not usually involved. It can be in certain types of civil litigation, but mostly we're talking about disputes between companies or private individuals. And we don't talk in terms of guilt or innocence in a civil proceeding. We talk in terms of somebody being liable, usually for damages. And remedies are usually the payment of some sort of damage or some sort of injunction that sort of prohibits somebody from doing something.
And that actually helps me. With my next question here was, this first concept I want to talk a little bit about was, kind of the various stages of, a lawsuit, not necessarily a criminal proceeding, but a civil lawsuit, like you mentioned.
So, it might be helpful just to kind of talk a little bit about the difference in stages between a civil lawsuit and a criminal proceeding. Even though criminal proceedings are not my area of expertise, I can sort of rough out sort of the various stages. Usually when it comes to a criminal proceeding, it begins with some incident or set of events that leads to somebody being charged with a crime, and usually there's some sort of investigation to determine if that person should be charged with a crime. And if so, that person's arrested. And after the arrest, there's usually some discussion of bail, whether the individual should remain in custody or will be released pending trial. And after that, there is an arraignment where the defendant is informed of the charges against them and they enter a plea. After that, there's a period of pretrial hearings and motions sort of focused on narrowing the issues for trial or suppressing the evidence that might be brought against the defendant at trial. And of course, there's a trial, and after the trial, if the defendant is found guilty, sentencing. That's sort of my best stab at all the different stages in a criminal proceeding. When it comes to civil lawsuits, I essentially break out a civil lawsuit into 4 separate stages. So the first stage is, the incident or incidents that led somebody to kind of want to file a lawsuit against somebody else. The second stage is the actual filing of a document called a complaint in a court of law. That's what actually starts the lawsuit. The third stage is a stage where the parties involved in the lawsuit marshal or locate the evidence they need to kind of prove their case or their defense to a case at trial. And then finally, there's a trial. So 4 separate stages in a civil lawsuit, far fewer sort of discrete stages than, say, in a criminal proceeding.
And as somebody who's followed criminal proceedings, those small little hearings, it can seem to take forever.
Yes.
Honestly.
Yes.
So, you mentioned kind of the 4 different stages. What are the stages that really differ when it comes to these 2 different types of proceedings, or maybe a couple big ones that differ?
Well, in terms of a criminal proceeding, all of the things that involve the arraignment, right? The sort of letting the defendant know what the charges are, and then having the defendant plead, whether say whether they're pleading guilty or not guilty. That does not happen in a civil lawsuit. And even the sentencing piece of it, if a defendant is found guilty at a criminal trial, then we move on to the sentencing phase. That does not happen in a civil lawsuit. There are some similarities between a criminal proceeding and a civil proceeding, and the big one is that stage where the parties are able to get the evidence that they need to represent themselves at trial, and also to narrow the issues for trial.
And actually, following up on that, I'm sure we'll delve into the trial part later on in the conversation. But when it comes to that discovery process, what's similar or what's different, rather?
So, in a civil proceeding, the rules of civil procedure allow any party in a lawsuit to sort of ask the other side, all the other parties in the lawsuit, for information and for evidence that could be relevant or useful in terms of going forward to trial. But if they don't ask for a specific piece of information, if they don't think to ask for a specific piece of information, they won't get it from the other parties, even if that piece of information is helpful to them or relevant. So they really have to be thoughtful and really think about all of the different ways to sort of ask questions to get the information they need. In a criminal proceeding, it's a little different. One side, the prosecution, must disclose to the defendant all of the evidence that the prosecution has that relates to guilt, innocence, or punishment. And they have to do so regardless of whether the defendant asks for that information. And, the prosecution, the government, does have some limited rights and ability to get information from the defendant, but it is not as it's limited. And, of course, for example, a defendant cannot be required to turn over evidence that incriminates them or against their interests. So discovery in a civil lawsuit is generally considered to be far broader for all parties involved than, say, in a criminal proceeding.
So when it comes to civil proceedings, do companies or whatever, do they have to turn over all the documents? Is that kind of how it works broadly?
If a document is considered relevant to the issues in the lawsuit and not otherwise covered by some sort of privilege, say, for example, the attorney-client privilege, yes, companies have to turn over documents that are requested.
That's so interesting. And, the second concept that I, think is very important for people to understand is the discovery phase, which, we're talking about now, and what can be brought as part of exhibits. So when people are thinking about drafting documents, how can this potentially show up as part of litigation and, again, become part of discovery?
So a document drafted by an employee in a company could show up potentially as an exhibit to a complaint that's filed to start a lawsuit. It could show up as a trial exhibit. So at the actual trial, they blow up, documents into these big poster-sized exhibits, and there is your memo or your email there for the jury and everybody in the courtroom to see. Going back to documents being attached as exhibits to complaints, complaints are usually considered to be a court sort of litigation documents filed in court are usually considered to be public and accessible to the public. So if you, as an employee, drafted an email that somebody thought I'm going to attach as an exhibit to my complaint, there is the potential that, that exhibit is going to show up in the news media, and find its way to the internet if people think that there is some relevance to letting the public know about this particular document. And then there's just the whole, everything you've written, if it's relevant to the issues of the lawsuit, is turned over to the other side. And so they just weed through all these documents. So people are seeing, people you never even dreamed would be looking at a letter you wrote, an email you wrote, a text message you wrote. You never, a lot of people could have their eyes on that document, and you never would have appreciated that when you first created the document.
I'm wondering if, with your experience, have you found that people are kind of surprised at that like an email they drafted, 5 years ago out of the blue could ultimately turn up as a piece or an exhibit? Yes.
People are surprised to see a document. They don't even remember creating certain documents. They're surprised to see them show up. And when I say documents, I'm talking about things like planners, even Post-it notes that you've written and may have kind of put in a file and never thought about it, text messages that you've sent. All of these could potentially show up, and they could show up and you'd be surprised to see them, but then they could show up even in lawsuits you're not involved with. So you're not even aware that records that you have created are being used for whatever purpose.
And again, I think you said they're public after the case, correct?
If there are certain documents that are filed in a courthouse as part of sort of like the records of a case, not every document, but if it's filed in terms of an exhibit to a complaint or a particular motion or memorandum of law, yes, for the most part, they're public.
Perfect. And actually speaking on this topic, I just really got a great question in from Allison. So Allison just checks in real quick and just wants to know about, how would an NDA or a CDA document correlate in court, essentially?
I'm not exactly sure. So an NDA document is a non-disclosure agreement. And so if the question is how would a non-disclosure agreement prevent a certain document from showing up in court, it really depends on the terms of the non-disclosure agreement. Usually, if a document is relevant to the issues in the lawsuit, when we're talking about preventing that document from seeing the light of day, we're talking about actual privilege type documents. Those, the privilege is sort of the most protection you can have in terms of preventing something from seeing the light of day. And of course, privileges can be waived. So, even if you think something is covered by a certain privilege, if somebody has done something to waive the privilege, then a document does end up being disclosed to the other side.
And I will definitely keep that in mind anytime I'm drafting an email. So I just wanted to mention, one thing when we're talking about, documentation this broad. So am I correct in saying that, like you mentioned before, emails, text messages from work, phone calls, voice messages, kind of all that stuff fall under this category?
Yes.
Perfect.
Yes. If something is relevant to the issues of the lawsuit, then it needs to be produced. And that would involve even what people call metadata about documents. So, for example, a document that you create, a memo, let's say you witness an incident and you write up an incident report and you claim that you wrote up the incident report right after the incident happened. There is information where people can go in and see when that document, that memo you wrote, was actually created, and if it wasn't exactly right after the incident, that's information they can use to kind of discredit you or what you've said. So even documents that you thought you deleted, you may have written an email or received an email and deleted it. You may have started the draft of a document and deleted it. There are ways to go in and retrieve emails that you thought were deleted and documents that you thought you had put in the trash. As in terms of the computer, there are ways to get at that information. Even if you are using your personal phone and you have a text message, if that text message relates to the issues in a lawsuit, you likely will be asked to turn over that information.
That's so interesting. And for any employee out there who's drafting, documents for their employer, and again, like we mentioned, emails, text messages, what's something they should keep in mind, even if their employer hasn't been involved in, any legal or civil litigation?
That's a great question. I think one thing I would sort of advise employees and others to think about when they're sort of creating documents is to keep them as professional as possible in the workplace. Informal language, jokes, sarcasm, really at times may appear to be harmless, especially when you're first creating the document. But many times they come back to hurt you or your company, particularly when they surface years later. They're taken out of context. When cultural sort of norms have shifted in terms of what's appropriate and what's not appropriate. So really trying to keep the communications written and oral as professional as you can in the workplace. And that's hard to do because many of us form strong friendships in the workplace. And so you're sending a work email to a good friend of yours. Why, it's hard to kind of keep it really formal and to keep the informality out of it, but you have to be really sensitive to trying to keep it as professional as possible because later on, it could come back to haunt you.
And along this lines of keeping, everything professional, what would you say is the number one thing that people do, maybe that they shouldn't, when it comes to drafting work emails, text messages, communications? Is it the, maybe sending a funny joke or a funny meme or something, or maybe making it not as professional as it should be?
That's exactly sort of the number one problem is not keeping it as professional as it should be. Calling people sort of nicknames behind their back or getting too emotional when sending emails. Something happens in the moment and you fire off an email without thinking about the tone and the language you're using in that email. So, really thinking about before you sort of start to type out that email, making sure that you're in the right frame of mind to send a professional email. The other thing, too, quite frankly, is typos and sort of not being careful about, trying to have something that's, it doesn't have to be grammatically perfect, but something that reads well and shows an attention to detail and care and thought. So many times, if something is done and it contains a lot of typos, that could reflect, especially, let's say, the issue in a lawsuit has to do with quality control or safety. And so they can look at some of these documents created, whether they're emails, incident reports, whatever, and even just kind of point to all these typos to kind of show, okay, if you're sloppy in this, what else, what other areas in your work are you sloppy in?
That's why I try to keep all my emails very, very short.
Right.
and to the point.
And I think that that's something that's good advice to others. Yes.
Yeah, it's short and to the point. Audience, remember that.
Yes.
And we actually just got a great question in from Yuli, and I just want to touch on this very, very quickly. Then this was about, bringing in relevant documents and everything like that. So Yuli asks, is there a specific system that is utilized to analyze what documents are relevant and what kind of means of investigation are taking place for these scenarios? So like accessing personal phones and stuff like that.
Yes. So what happens in civil litigation is there's this process of where the parties send out written requests for documents.
Okay.
And these written requests are very detailed as to what they're looking for. They could say all text messages from, whether work phones or personal phones that relate to X. Those requests are delivered to the party that they want the information from.
Okay.
And that party has the right to kind of look at the request and say, this is inappropriate, we're not going to turn over this information. And go to the court and say, do we have to turn over this information? We don't believe it's relevant. It's too far afield. It's a fishing expedition. And then the court will determine yes or no. But the idea behind discovery is we want as much information to flow as possible. So the courts really are sort of kind of bent towards allowing more discovery than limiting discovery. If documents are required to be turned over, usually the attorneys who represent the company who have to produce the documents gather the information and they go through the information themselves before they turn over the information to the other side. They'll remove what they don't think is relevant. They'll remove and kind of note what they think is covered by some sort of privilege that might be sensitive, that might contain trade secret information. They'll remove that and kind of make a note that we've removed these things because we believe they're covered by privilege or trade secrets. And then the parties can kind of fight over whether it really is covered by privilege. So there is a mechanism to kind of have the documents kind of reviewed by the parties' attorneys before they're turned over to the other side. And it's in that sort of procedure where, yes, the attorneys representing the company determine if certain documents that they have to turn over might be problematic, and it gives them time to figure out how to deal with that.
And Yulia, thank you for that question. And I wanted to just kind of take a step back when we were talking about, drafting emails, text messages, and keeping everything very, very professional. So, what terms or phrases should we use that can maybe help us communicate effectively with our company's attorney?
I can't really think of any standard or common terms or phrases that a layperson should sort of keep in mind when communicating with an attorney. I think it's a myth that many people think that they have to speak a certain way when they're communicating with an attorney, and that's just not true. In fact, attorneys would rather you speak the way you're used to speaking in terms of your area of business, and then if the attorney is confused or needs you to explain a certain term, they will ask you. And then also, if an attorney is speaking to you using legalese or terms that you don't understand, legal jargon, you should feel empowered and to say, I don't understand, would you please sort of explain that to me sort of more plainly? So there's no, in my opinion, any kind of standard or common term that somebody should keep in mind to use when communicating with an attorney. That said, I will share that there is a tendency on the part of some to, if they're communicating with an attorney in writing, say by email, they'll want to put the phrase attorney-client privileged communication on the document or in the email. And there is a time and a place for that, but you have to be thoughtful about it. Just because you're communicating with an attorney does not make the communication privileged. It has to be, among other things, for the purpose of seeking legal advice. And many people will just put that label on any document
Okay.
that they're sending to an attorney, or they think that just because they CC an attorney on an email that the document becomes privileged and is shielded from disclosure. That can backfire because courts frown on this sort of thoughtless or just automatic labeling of every communication as attorney-client privilege when it really doesn't. The label isn't justified. So, need to think carefully about just using the term attorney-client privilege communication all the time.
And that's actually really surprising to me that, people would just use it very, very broadly, assuming like, everything falls under attorney-client privilege when it actually doesn't.
Right. There's, and I won't share the name of the company, but a company did it was in the news that their employees were doing that, and that was not appropriate. And I'm not saying that they told their employees to do it, but it did create a little bit of a kerfuffle in the media.
I'm assuming they weren't doing it with like every single piece of communication they had.
Yes.
Oh.
They were doing it with every single piece of a communication sent to an attorney, or automatically adding an attorney's name. So say you and I just were emailing, and I just thought, you know what, I don't want anybody to kind of see this email. I'm just going to put an attorney's name on it. And that was not, and it was not for the purpose of seeking legal advice from that attorney. So.
It's good to know. And I'm sure as, attorneys prepare for depositions, we're going to shift gears a little bit. There's tons of communications going back and forth, like we've been talking about. At its most basic level, when it comes to our communications with our company's attorneys, what are some things maybe you need from us, or something that, you've seen in your past where it was like, hey, I wish, a lot of my clients work this way or something, or provided me with this?
Right. Every attorney is different. And every sort of relationship between an employee and an attorney is going to be different. So what that means is there has to be an understanding upfront between the attorney and the person the attorney is working with about communication styles, what works for one, what works for the other. So, there should be some understanding about the kinds of information that should be written down in a document, or when the attorney would just prefer that you pick up the phone and call them, and don't just automatically put something down in writing. So that conversation has to happen early, at the very beginning of the relationship, and it needs to be a conversation that you have. It's an ongoing conversation because needs change, and you learn more about each other during the relationship. So it is a partnership in terms of what works for you, what works for me. And don't ever think that the attorney should be sort of like, should not be a power imbalance. You as the employee have the right to kind of say what you need in terms of communication styles, right? So if... would you prefer me to call you when you want to speak to me, or would you prefer me to email you? And if you prefer me to email you, do you want it just to be the bare kind of minimum in the email, or no, I actually prefer only communicating by email? Okay, if I communicate by email, how soon will you respond to that email? I'm not holding you every single time, but just to get some of these things nailed down, that certainly helps in terms of having a productive and effective communication relationship between attorney and employee.
And, along this line of, proper communication channels and everything like that, Priya checks in just very, very quickly, and she asks, communication through channels such as, Slack or Messenger, some of these very, very less formal communication methods. How does one balance the expectation to respond quickly versus taking time to wordsmith every sentence? So just given these programs are very, very informal. So how do we kind of balance that out?
Just a conversation. My version of quickly may differ from somebody else's version of quickly. Saying, okay, I will, here's what my day looks like. And yes, I would like to be able to kind of respond in the second that you sent me a message, but if I'm in meetings, blah, 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 I can't get to. So, just having that back and forth understanding with the people you're communicating with really does help a lot.
Awesome. Well, Priya, thank you for that question. And I kind of want to switch gears a little bit and talk about the concept of, depositions. When it comes to testifying for a lawsuit, what are some things employees should keep in mind if they ultimately are called to testify?
So I'm just going to say, tell the truth. Tell the truth, even when you think the truth is going to be damaging to you, the employee, or to the company you work for. Many times people think that the information they have has more of an impact than it actually does, and that forces them to do things such as, withholding information or not providing accurate information. The best thing to do is to, before the deposition, share with the company's attorney sort of your concerns about being deposed, and also sort of the information you have and why you think it might be harmful. Many times the attorney can reassure you that we already know this, or it's not as harmful as you believe, or thank you for telling me this, now we have to change strategies. But the time to have those conversations is before the deposition starts and not in the deposition. There's so many ways to deal with an employee having information that might not be the best for the company. But one way that shouldn't happen in terms of dealing with it is to provide false testimony. And then the other thing too is if you are going to be deposed, and if you're going to be represented by an attorney, then you should require the attorney or ask the attorney to set aside time and enough time to meet with you and prepare you properly for the deposition.
Yeah, that's what I was going to ask you. That's actually what I was going to ask you next. Was there any, preparation as far as, this is some questions we anticipate they might ask or something? Is there any prep there?
So ideally, yes, but not every attorney does that with a particular witness. And so the witnesses should feel, empowered to kind of reach out and say, I really would like to meet with you prior to this deposition to find out what this deposition is about, what are the issues in the lawsuit, what are the questions you think they might be asking me, what are the documents you think that they might show me, and then let the attorney move from there. Sometimes they may not show you the actual documents, but it's their job. If they're going to defend you at the deposition and they want the deposition to go well, to make sure that you feel comfortable and at ease so that you are in the sort of the best possible position to provide full and accurate testimony.
And, while we're thinking about, depositions and all that, when it comes to, some of these major lawsuits, some of the really, really big ones, who can be called to testify? Is it just a small group of people, or is it, any employee? How does that work out?
Anybody can be called to testify in a deposition or at trial. I mean, I'm overstating this a little bit because there are rules in terms of subpoenas and people being not, physically located close by in terms of calling them to testify. But really, if somebody has knowledge that somebody else thinks might be relevant to the issues in a lawsuit, then they have the potential to be called as a witness in that lawsuit.
Wow, and not getting too deep into the weeds, but do both sides generally get an idea of who is going to testify well before depositions and trial?
Yes. For the most part, what happens is during the sort of the discovery process, one of the questions that's asked is, okay, who are the people who have knowledge of the issues in this lawsuit? And so names are provided. Also, even in federal courts especially, parties affirmatively have to provide that information at the beginning of the lawsuit. They may not have all of that information, but they have to start to indicate who they believe might have knowledge that the other side, relevant to the issues in the lawsuit. And then as you get ready for trial, you want to have a trial witness list. And on a trial witness list, you want to be over-inclusive, because if somebody's name is not listed on that list, then it's harder to actually get them to testify at trial. So people tend to kind of list as many names as they can of people just in case. You never know what happens at a trial where you might need to call somebody you didn't anticipate before. So you just want to have sort of as long a list or as comprehensive a list as possible.
And I think I probably know the answer to this, but is the list of folks that are going to be deposed generally the same as the folks who are going to take the stand in trial?
I'm going to say yes and no. Okay, so the list of people to be deposed is going to be ideally, it's going to be broader, right? Because it's in the discovery process that you really find out, okay, what knowledge does this person have? You depose them and you realize maybe they don't have as much knowledge as you thought, and so they would not end up on your trial witness list. So, discovery is meant to kind of narrow down, ideally, the sort of number of people who have been listed on some sort of possibility as having knowledge. It should be a smaller list for trial.
Perfect. And I just got a great question in from Keith. And Keith wanted to know, can you give some examples of, bad decisions by people that maybe resulted in legal consequences? That's a very broad question, but that's what Allison asked.
So I'll give a broad response, or I'll give just an example. So one example would be you witnessed an interaction between two colleagues at work. Say you see somebody sitting down with their arm around a younger work colleague, and immediately you dash off an email to HR saying, I just saw X sexually harassing Y. You have put something in writing that is just your opinion. You have no idea what you actually saw. It would be better if you had to send, in terms of communicating the information, should you pick up the phone and call, depending on the timing, right? Somebody in your HR department, or if you are going to send something in writing, being very factual, describing what you saw and refraining from making sort of judgments or interpreting what you saw. Because, yes, if you're putting that term in a document, that could potentially, result in some legal consequences.
And, for a lot of us who, just kind of work every day, who, aren't attorneys, what are some skills that we as employees really can analyze as far as issues similar to the way, an attorney might, to help make it easier on, our company's counsel?
Wait, so are you asking me how, if you were a company employee and you had an issue and you wanted to analyze it sort of the way a lawyer would? Is
Yes.
that okay? So what I would say is to analyze an issue, a business issue, the way a lawyer would analyze a legal issue, is you really need to sort of break your analysis up into steps and follow those steps. So individual steps, and then follow those individual steps in order. So the first thing is, first step is to first kind of identify the precise issue that you need to analyze, and the precise question that you need to answer. That's big, because a lot of people don't sort of narrow down and really focus. What is it I'm supposed to be focused on? So you need to identify that first. That's the first step. Then the second step is for you to see if there is a company rule, a company policy, or a rule or policy outside the company that addresses that particular issue or rule. So something objective that you're going to use as sort of your guideline to kind of analyze the issue. And once you've determined that, then the next thing is to Now look at the relevant facts of the situation. So everything in order. You don't look at facts first. You look at issue first and whether or not there's a rule or a policy. Then you look to see what facts for the particular situation are relevant to that particular rule or policy and how those facts are relevant and why. Attorneys always look at situations objectively. So you're examining the strengths and the weaknesses of a particular position. So you're not sort of focused on trying to get to a particular result. You're really looking to see, okay, what's the strengths of this result? What are the weaknesses? How can I respond to the weaknesses before you arrive at your final conclusion? So 4 steps that you have to take in order. And if you do those 4 steps and you do them in order, you will almost always arrive at a sound conclusion that is defensible in terms of when you're working with somebody in your workplace or just dealing directly with an attorney.
It's very, very important note. And thank you for that. And Chen checks in, and this is a very interesting question. So we've been, talking a little bit about, communication between, employees, employers, and, in-house counsel. But Chan asks, in what ways does the application of legal communication principles differ when communicating with internal stakeholders, colleagues, management, versus maybe external parties, so clients, regulatory bodies, things like that? So what are kind of the legal concepts around that when we're thinking about outside communication?
Right. When you're communicating with people who you regularly communicate with, it's going to be a lot less formal than, say, communicating with an outside entity. The problem there, though, is when something is a lot less formal, again, there's that professionalism, fighting against sort of not being as professional as possible. There's a lot of, there's a lot of knowledge, right, that you already know, so you don't put things down in a document to really have the document be as complete as possible. Years later, when you're not there, they're not there, there is nobody to kind of fill in the gaps, that's a problem. So that's something in terms of when you're dealing internally, you always have to be thinking about, I don't have to kind of put this down, they know it, that sort of thing. But 10 years from now, that omission could become a problem. You don't really have that much of a problem in terms of the external communication, right? Or people you don't sort of regularly work with, because now you have to educate them about certain things. So, and naturally, you're going to be a little bit more formal and a little bit more professional. So I would just say, just as a guideline, to try to keep your communication the same, no matter if you're working with somebody within a company or outside of the company. Not easy, I know, but from sort of legal consequences and legal ramifications, it's better if you adopt that approach.
And just very quick, you mentioned that in theory, any employee can essentially be deposed. I'm wondering, does that apply to employees who may have left the company, retired, anything? Can they also be called as well?
Yes. Okay. So if somebody's left the company, if they can be found, yes. Okay. But remember what I said, there's issues in terms of subpoenas, where they're located, but in theory, yes.
That's good to know. Well, thank you for that. And one thing that I did want to ask you was, you're obviously the faculty author of our legal writing communication certificate. So broadly speaking, who should take the certificate?
There's so many people who would benefit from this certificate program. Certainly those in the workforce who regularly work with attorneys, whether they're the company's sort of in-house attorneys or external counsel. Those who have an sort of HR function, or those who conduct interviews for the company and have to write up reports of those interviews. but just anybody, who, it's always useful to be able to appreciate the many ways in which the actions you take or don't take as an employee could impact the company you work for.
And I'm wondering, just very general, I thought about it now, but when it comes to, kind of students and, kind of teaching them about the, different legal communication styles, is there kind of one theme that arises as far as, kind of writing legal documents and things like that maybe not all, but some of them struggle with?
I think a lot of students struggle with, now eventually they master this, but they struggle with, I went through those 4 steps in terms of legal analysis. They struggle, believe it or not, with sort of being precise in terms of identifying the precise issue that they're supposed to be analyzing.
Okay.
And then the other big area is the really kind of figuring out why facts apply to a certain rule that they're sort of working with, and explaining why those facts apply, how they apply, and then thinking about counter arguments.
Interesting. Okay. And, what's one thing that you think would be really, really helpful for folks when they finish the certificate, or that one skill that is really helpful that they can, take and use as they continue their careers?
Definitely the skill in terms of taking the 4 steps in when you're analyzing a particular issue. But then, I think it's just really helpful, for those who finish this course, that they're going to be able to kind of demonstrate an appreciation for the legal consequences of their actions and their written communications. That's going to be clear to the people that they're working with. Their oral communications are going to be more thoughtful, professional, and they're not going to create unnecessary risk for the company. If and when they work directly with the company's attorneys, I'm confident that they're going to impress those attorneys with, thoughtful, informed, intelligent questions geared towards kind of making sure that relationship is as productive and as effective as possible.
Well, Michelle, thank you so much for joining us. My very last question is, if you could kind of reach out to our audience, give them, one piece of advice or one thing to think about as they continue their day, or, potentially have communications with their company's in-house counsel. What's kind of that one thing you would want them to walk away with?
Not to be, I know I talked about a lot of don't do this, or these skills are skills that can be learned. And so not to be intimidated by anything I just said in terms of what not to do as an employee working with a company or company's attorney.
Awesome. Well, Michelle, thank you so much for joining us. Audience, thank you so much for joining us. Have a great rest of your day, and we'll see you at the next keynote. Have a good afternoon.